Now, X, while walking, he was walking on the sidewalk, and then he got hit by an overspeeding ambulance owned by the government. Now, because of this accident, he lost his 2 feet. So he lost his feet. Now he's crippled. Question now, so does he have loco standi? Does he have standing?
Sorry for laughing, Dean. It's just an ironic statement.
Why?
The standing and him losing his 2 feet. But in all seriousness, X would have the locus standi to file a case for injuries or damages that he incurred because of that accident.
After he lost his 2 feet, he would still have standing.
Yes, he would have a legal standing.
Okay, now let's discuss the case of Falsis. Now, in the case, we know what happened. So, according to Jeffrey, so he filed a case challenging the constitutionality of several provisions of the Family Code. Now, so let's focus on the question of whether or not there was an actual case or controversy in order for the court to entertain the action and go for a review of the constitutionality of those provisions which are being challenged by Falsis. Was he able to establish the existence or the presence of an actual case or a controversy?
May I answer, Dean?
Sure, go.
In the ruling of Falsis, he was not able to establish that he had an actual controversy happen to him, and he was not also directly affected by the limitation of the marriage to a man and between a man and a woman, because in this case it was found that he wasn't denied a marriage license. He was also not denied a same-sex marriage. With this, his entire case was basically based on a hypothetical situation.
Hypothetical situation.
Yes, Dean, because his entire argument was that it violated equal protection, due process, and religious freedom. But he never gave substantial evidence to prove that these violations actually happened to him.
Yeah, but his argument was that the very existence of the family code, these provisions that he was challenging, already prevented him from even entertaining the thought of marrying somebody from the same sex.
Yes,
from
but
having a long-term relationship with with a person of the same sex.
with that being, the law doesn't actually prohibit him from entering a long-term relationship
With a person of the same
with a
sex and
person of the
marrying
same
that
sex.
and marrying that person.
Yes, it does prohibit him from marrying that person, but
Yeah, precisely.
going back to this,
That's his problem. He's being prevented from exercising the right to marry. While others can exercise the right to marry, he cannot because of the very law that he was challenging. So he alleges that it violates his right to due process, his right to life, right to pursuit of happiness, and his right to equal protection. Because while others could marry, he could not.
but the fact of the matter still stands, Dean, that he has not applied for a marriage license or even.
Now, may I ask you, assuming he applied for a marriage license, would the marriage license have been granted?
It would not have been granted, Dean.
So it would not have been granted. So what's the use of applying for a marriage license knowing that it would not be granted? Now let me bring up this matter about the next case in the third case, Fernandez versus Torres. In Fernandez versus Torres, these are entertainers and they would like to be deployed abroad, except that at that time, when this case happened, there was a ban on the deployment of entertainers abroad. They filed a case asking asking the court to declare this memorandum or something to be declared unconstitutional because it prohibited them, it prevented them from exercising their right of having gainful employment abroad. But what happened in that case? The court said there is no actual case or controversy. Why? Do you know?
If I may, Dean, the court ruled that there is no actual case or controversy at hand because while it was a circular note, I believe, but the Department of Labor and Employment issued, yes, they said that those who are under 23 cannot be deployed overseas. However, in that same provision, it also states that the Secretary of Labor and Employment may, for justifiable reasons, exempt the performing artists from coverage hereof. And therefore, that means that it's not an absolute ban. And the petitioners who filed this petition.
Okay, so had they applied for the exemption, was it possible that the exemption would have been granted?
Yes, there would
It
have been
was
a
not
possibility.
guaranteed that it would be denied, right? So
Yes.
had they applied, there were two possibilities. Either the application for exemption would have been granted or it would have been denied.
Yes.
So there was no way to know for sure except for them to file the application for exemption. And therefore, when they did not file the application for exemption, but instead they went directly to court to challenge the circular, so their action was premature because there was
Yes,
an
it was
available option to
premature.
them, there was an available remedy, and they did not take that remedy, right?
Yes.
Now,
Yes.
we relate that to the case of Falsis. Had he applied for a marriage license, would it have been granted?
Yes. If he
License,
applied for marriage license and it was
to marry somebody of the same sex.
yes, and if it were
Would it have been
denied,
granted? Was
right?
it possible that it might have been granted? Was it possible?
No.
No, it's not possible.
No.
So we cannot fault him for thinking, that even if he filed for a marriage license, he knew for a fact that it would be denied because there's only one possibility. If he applies for a marriage license to marry somebody of the same sex, it would be denied. So what's
Yes,
the use of
he
filing?
definitely-
What's the use of filing?
He definitely had a valid concern because yes, right now in the Philippines,
Yeah,
there's
so
no
precisely that's
way
the distinction between the case of Falsis and the case of the petitioners in Fernandez versus Torres. So in
Yes.
Fernandez versus Torres, it was premature for them to go to court because there was still an available option to them. But in the case of Falsis, there was none. Because even if he applied for a marriage license to marry somebody of the same sex, it would definitely be denied. There was no other possibility.
Yes.
Because the very existence of the provisions of the family code, which defines marriage as a permanent union between a man and a woman, and that the requirement that legal personality between the parties must be a male and female. So the very existence of these provisions prevents him from exercising or even entertaining the thought of marrying somebody of the same sex.
Yes, Dean. However, in Falsis versus civil registrar, an anticipation of harm does not necessarily mean direct
But the
injury.
harm is already present. He was saying that the very existence of the law, the very existence of these provisions in the family code already causes him harm.
Yes, however, he cannot directly prove that it's precisely because of the family code that he cannot marry someone.
Is needed? What more proof is needed when even if he entertains the possibility of applying for a marriage license, it would definitely be denied. So what more proof is required for that? Does he really have to go through the process of, and then when he knew for a fact that it would still just be denied? Now, in the case of City of LA versus Lyons, Lyons here had a conflict with the law, particularly a traffic violation, I think, and then the LAPD applied a chokehold on him. And then he got injured, he got hospitalized, and according to him, he in fact almost died because of what he suffered. And then he filed a case. He applied for an injunction. He filed a petition for injunctive relief, okay, against the LAPD to stop this practice. So what did the court say? Is there an actual case or controversy that is already ripe for judicial determination?
No, because he had to show that in order for there to be an actual controversy, he had to prove that the police officers always choked citizens, wherein they always used unnecessary force and put them in a chokehold, and therefore the court ruled that he didn't have enough case. He didn't have an actual case.
So even after suffering that, even after he was a victim of that particular practice, so what do you mean? He has to violate traffic violations again, and then and see if the policeman, the LAPD, would again apply a chokehold on him. Is that what you're saying? So we wait for somebody to experience it again before the court will issue an injunctive relief against the practice.
In a way, that's what because according to the court, what they said is that he cannot file a case on the grounds that he may be put in a chokehold in the future. He cannot file a case due to a possibility of that happening.
So the court was saying, what he experienced was already in the past. So it was already a past injury, right?
Yes.
And it would not be enough for him. It would not give him a basis, for him to have standing to seek for an injunctive relief. So, but in effect, if that is the theory and if that is the principle that will be applied, after a person suffers an injury because of this chokehold, by the time he could file a case, the injury is already in the past.
Yes.
So if that is the case, then no one will be able to file a case against the chokehold, because by the time one files a case, the injury will already be in the past. But what's the requirement for a person to have locus standi? Isn't it enough that he must already suffered an injury, either direct or concrete injury, like in the case of Lyons?
Yes, he had locus standi in this matter.
Okay, so why was his application for injunctive relief against the practice denied by the court?
It was denied because, again, it was his basis was on the claim of a first of all, it's a hypothetical scenario, and second of all, it was not proven that the police always did it. So therefore, his case should be against the police
But
and not against.
But they were able to establish that there have been a lot of victims already.
Yes, that's actually true.
So isn't that enough? Should everyone who faces a traffic violation stop, be subjected to the practice before the court can issue an injunctive relief against the practice?
No.
So no, practically. So what is the court trying to tell us here?
If I may speak in a personal from a purely personal standpoint, attorney, I remember when I was reading this case, I actually disagreed with the court because, yes, I do agree that, especially in the case of City of Los Angeles versus Lyons, we have to remember that Lyons is a Black person, and there are a lot of cases, and it's proven by statistics that Black people actually do have a higher rate of being subjected to police brutality. However, I believe what the court is trying to say is that they cannot issue like a blanket statement where like all police are not allowed to put a chokehold, which I would understand, but I think that I believe that the court should have also considered the protection of the Black people who are very obviously, very statistically subjected to these brutalities.
Okay, so we go back to the case of Falsis. Okay, so what learnings from the city of LA can we apply in the case of Falsis? So what about this argument that the very existence of the family code provisions that he was challenging already affected him? It already provides for the concrete, direct and concrete injury that would give him locus standi to challenge the constitutionality of these provisions.
So applying the logic from LA to Falsis, I still hold on to the logic that Falsis still did not have substantial evidence for a case, considering that once again, he has not had any rights denied unto him specifically, despite the fact that he knows applying for a marriage license or asking for a same-sex marriage to be solemnized will be denied. The fact of the matter is he has not had an actual situation or action be taken against him, as compared to the case of LA versus Lyons, wherein Lyons already suffered an injury to which was an action taken against him by the police.
Yeah,
So
but even in the case of despite the fact that he already suffered actual concrete injury, the court still denied this application for injunctive relief. I'm talking about the case of Leon's.
yes, for Lyons. For Lyons, I actually agree with the logic of Chelsea in regards to this, that while obviously we do not hope for more people to get hurt by this practice, but the whole basis for an injunction is that you have to prove that this action that was once once happened to you could substantially happen again. The fact, if there were other cases similar to him or were basically the exact same situation that happened to him, that strengthens his evidence, his argument that this practice, the chokehold of the police, could happen to him. Since that was not proven, that's why his petition for injunction was denied. If other cases were present, or if he had used other cases, if that had happened, that would have strengthened his case in regards to the injunction.
Okay, now in order to close this cases and this issue, so in the case of Falsis, going back to the case of Falsis, regarding the issue of whether or not there was an actual case or controversy as one of the requisites for the exercise of judicial review. So why is there no actual case or controversy in this case? Give me a legal basis. Give me a legal basis for that, and for any conclusion that you might make on that on this matter.
This will, admittedly, Dean, this will sound like a circular argument, but I will hold on to the fact that for the requisites of a judicial review, we need to there must be an actual case or controversy. As we stated previously, since Falsis had no action directly taken against him, as stated, examples are an applying for a marriage license, there was no actual case or controversy. And additionally, may call into question the other requisite, which is that the question of constitutionality will be raised at the earliest opportunity. In regards to a judicial review, this third requisite actually needs to be
wait. Are you saying that since Falsis was saying that the very existence of the family code was already causing him a concrete and direct injury, so are you saying that he must have filed the challenge against these provisions of the family code as soon as the family code was promulgated and then it took effect?
No, Dean. He would have filed if he had an action that directly affected him, rather than when the family code was promulgated.
So it's not the taking effect of the family code, because that's what he was complaining.
Yes,
complaining about.
Not. It needs to be in regards to when an action happened against him.
Okay, so in order to close this case, so we just have to connect it with the requirement for an actual case or controversy, and then of course you base it on section 1 of Article 8 of the Constitution. So what is the requirement? There must be an actual case or controversy involving rights which are legally demandable and enforceable. And then the court, of course, was clear in saying that there must be a conflict or a contrariety of legal rights. And there must be a governmental action affecting or causing the direct or the concrete injury. So you are right in saying, therefore, that insofar as Falsis is concerned, since he has not filed a case or he has not filed an application for a marriage license, and the respondent in this case is the Civil Registrar General. May I ask, what has the Civil Registrar General, what has this office done to Falsis that would give him a right to bring this office to court?
If I may, Dean, I believe that's actually one of the reasons why the court ruled against Falsis, because there was no reason why the civil registrar office had anything to go against him. They're only in charge of filing the information. They're not actually taking an active stand against, or like they're not taking an active action against his rights.
Or would the ruling have been different if Falsis, instead of naming the Civil Registrar General as respondent, what if he named Congress instead, including the late Corazon C. Aquino, who approved the family code? No, it's not Congress. No, this is EO. So this is from the president directly, right? So would it make a difference if Falsis named the executive branch, the one responsible for issuing the executive order, which promulgated the family code of the Philippines?
If I may, Dean,
Yeah.
even if Falsis filed the case against Congress or any other party, it still stands that he had no actual case or action taken against him that would have caused direct or future damages or injury.
So you're saying that the mere passage of a law or the mere existence of a law would not be enough to give you a legal basis to file a case against the constitutionality of that law?
May you repeat the question again, Dean?
Okay, for example, there is a law.
Mhm.
It will affect you if it will be applied or if it will be implemented. But as things stands at present, it's not actually being implemented on you. So the very existence of the law, would it give basis for you to file to challenge its constitutionality? Can you not say that as a concerned citizen, when I read the law, I found that it is a patent, manifest, obvious violation of the Constitution?
Just
So
to
I don't have to wait until I am directly affected by it. So the very existence of that law, it is unconstitutional on its face. So as a concerned citizen, I'm bringing this case, and not only on my behalf, but on behalf of other Filipino people who might be affected by this law.
If it is a law, it's already implemented, it's already passed and approved, promulgated even. If it is a law, you can file a case even if the injury that is something that might happen to you, or it's possible that you would have a direct injury to it.
Mm-hmm. So there is no need to wait for the actual concrete or direct injury.
Yes, Dean, but we
So
also
why can't we not apply that to Falsis? Because that's exactly what what he was saying.
the future injury.
No, the very existence of the family code already affects him.
There needs to be a specific action that would happen to him in accordance with the law that he is claiming to be
So he cannot say,
unconstitutional.
I've studied law, and
Mhm.
then in my understanding, the family code, family code provisions violate my right to equal protection of the laws, violate my right to due process, right to life, right to pursuit of happiness, right to marry.
But we once again on we once again go back Dean, to the fact that there is still no actual case or controversy that happened to him. It might we go to the term that was used. It might affect his pursuit of happiness. It might affect a marriage license, but the fact of the matter is he has not applied for one, and regardless of his personal intention for a same-sex relationship, it doesn't affect the fact that there is no actual case or controversy.
Mm-hmm. Okay, thank you very much.